Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here this morning for the submission of 3 cases. The first case is Degenev versus Home Pride Contractors. That case is hereby submitted without oral argument. Our first oral argument of the day is Maribel, Abbas, and others versus Franklin County Board of Supervisors. It appears the parties are ready. Mr. Cady, you may begin.
Thank you, Your Honor. May it please the court, counsel. My name's Art Cady. I'm the attorney for Drainage District number 48 in Franklin County. Drainage District 48 may well be the first or one of the first drainage districts ever established in the state of Iowa. The drainage district, the law allowing drainage districts was passed in 1904, and this drainage district was established in 1905. It was originally created as Drainage District number 1 on October 3rd of 1905 to address wetlands and to create a drainage district through the district. The district encompasses about 2,600 acres originally. And it created a ditch 5 miles long running from north to south. The top width of the ditch varied, but it was deep enough and wide enough throughout its length that it was not traversable. So it split farms up. The average width, I think there was testimony that was about 32 feet, more or less. Farmers would have had to either construct a crossing or go around the ditch in order to farm both sides of their previous, of the farmland that was cut up. As part of the original proceedings, when the project was completed, notice went out to landowners like it does now, and notified them to make claims for any damages that they may have suffered as a result of the construction of the ditch. Many landowners did, in fact, submit claims. Some did not. Many of the claims were made, and I want to read a little bit from the records of the drainage proceedings. Many of them were kind of a template, but they stated on account, the claim for damages on account of the location of the drainage ditch upon and across my land. Another one said, I will have to have damages because it cuts my land into such bad shape. So quite clearly, this ditch was a major project in 1905, and it cut farms up.
When those payments were made and those claims were made, was there anything recorded in the land records related to those farms?
County recorder, no. It was in the drainage district records, but not in the land records. So in 1916, so we go from 1905 and 6. In 1916, there were other significant proceedings that occurred. First of all, the district was reorganized from Drainage District 1, and it was renumbered to Drainage District 48. And at that time, many of the landowners wanted some tile installed to facilitate drainage.
Question for you. When they renamed that drainage district, were there any changes to any of the parameters of what it entailed?
As far as the area of coverage, I'm unclear about that. The drainage district records do not reflect. I'm assuming there was probably some increase in size because there were at that time, I think, lateral tile also installed as part of the 1916 project that drained into the tile that was being installed at the bottom of the ditch. So the new project in 1916 called for installation of a drainage tile in the bottom of the original drainage ditch, which tile line went from 14 inches wide at the top of the installation, the top of the head of the ditch, down to 32 inches downstream. And as I recall, it covered about 2.5 of the 5 miles. The rest of the southern part of the original ditch was left pretty much as it was. So the new project resulted in the ditch being, having tiled installed in the bottom, and then having fill dirt installed over the top.
As I understand it, in the 1930s, because that ditch was filled in, that part of the property went back on the tax rolls, and those farmers had to pay tax on it. Is that right?
There were some proceedings. What happened is that after the 1916 project was constructed, there still were piles of dirt on each side of the ditch. Some of that dirt was used to fill in over the tile, but some of it was left where it was. And so over the years from 1916 to mid-30s, the farmers on their own, wanting to farm across, moved dirt and made it traversable so that they could cross that area where the original ditch was constructed.
What was the statutory basis for moving that property back onto the property rolls?
This has been it's a trustee district with the Board of Supervisors of Franklin County being the trustees. The supervisors of course, are also doing their jobs as supervisors. So I would like to make the distinction that when it was moved back onto the tax rolls, the supervisors were acting in their capacity as supervisors and not as trustees.
Significance to the fact that these farmers are now paying property taxes to the county with the same people running the county and the drainage district?
Result of the 1930 proceedings? Well, I mean, that was addressed in the Hicks case, which was also dealt with many of the same farmers and similar facts as this case presents. And in the Hicks case, this court held that the county did not lose rights in that ditch by allowing the farmers to fill it in. There were claims made that the district should be stopped from having that ditch because they allowed the land to be taxed. I don't think the tax issue is really the critical part of the case. It's ancillary, and I don't think that's determinative here.
When the ditch was redug, I guess, in those spots where it had been filled in 2017, am I right that it was sort of dug out wider than it had been?
It went from it was approximately 32 feet wide as originally constructed in 1906, and as a result of the 2017 project, I think it was expanded to like 100 feet at the top.
Any argument that at least for that additional space that money is owed for that, the damages are owed for that?
And I think the court ordered damages for the additional taking, and I'm not here to argue that was improper. I just believe that under the law at the time that there's no further compensation payable to the landowners for severance, which the land was severed in 1906. So
Meant that with respect to the difference between the right-of-way, the additional right-of-way damages versus the severance damages, that expanding it from 30, whatever you said, 32 feet to 100 feet, that in itself would have diminished the value of the rest of the land?
Again, the landowners had an opportunity that I think that was done in 1990. There was as part of the Hicks, and there were additional damages claimed and paid. So I don't, what I believe this case today presents is are severance damages payable. because the land was severed back in 1906, damages were paid, and
I mean, there's kind of severed as in, it seems like there's maybe two kinds of severance going on here. One might be like with respect to the 4.01 acres, that it was severed in the point that it became inaccessible. But my understanding of general severance damages is just when you do something to a piece of property, like put a ditch into it, it reduces the value of the remaining land, even though it's not covered by the easement. That's,
well, yes,
severances or severance, is there just really one type of severance damage?
that the 4 acres of the Reed-Meyer severance are not duly payable. That's a different fact than we have with the rest of the landowners and the construction of the original 1906 ditch.
Clarify then kind of exactly what your theory of damages is, which parts you concede the district court got correct, which are incorrect, and then tell me why you think the district court was incorrect on those things you're contesting.
District court was correct in in finding that the district did not abandon its easement rights after the original ditch was constructed and the proceedings that happened subsequent. We're not appealing that. I think the Hicks case also made the same finding. As far as the district court found there were damages payable for additional right-of-way that was taken, and we do not contest that. The district court found that Reed-Meyer were entitled to damages for the 4 acres that were severed. And there was an issue that the Court of Appeals determined that on that particular issue that there had to be a remand back to the district court to clarify the record on the taking there. So the only thing that we are seeking further review on is whether the severance, whether the plaintiffs are entitled to any severance damages at all. Clearly, they're entitled for additional right-of-way taking, but we don't believe that they're entitled to anything more than that.
That's the way the additional right-of-way damages were calculated, the manner in which those were calculated, or that number's correct?
Originally at the trial court level, but no, we're not on appeal. We're not questioning that. We're comfortable with paying those damages. And
More specific about when you say you're comfortable paying that, what do you suggest that the right-of-way damages are as opposed to the severance damages? Because it seems like the district court kind of rolled them into one for each property.
and I think you might be correct that they did roll it into one, and it may have to be remanded to separate it out. But the original, like I say, we are not contesting additional right-of-way damages. I thought there was the commissioners back when when notice went out for damage claims, the commissioners recommended damages be paid for the additional right-of-way taken. That's what.
Answers were, okay, thank you. Can I ask you another follow-up on, you said you were talking about that the Court of Appeals remanded for the taking. Was that issue about whether or not the deed needed to actually transfer ever raised in the district court and before it got to the motion to reconsider stage?
I don't think it did. I think that
Properly part of this case?
I would like to get it all disposed of as efficiently as possible, but I think an argument could be made. The Peterson case stands for the proposition, that's cited in the briefs, that when you have a drainage district that takes, that when there's an eminent domain taking, that you don't have to really go through the eminent domain proceedings. So I think
Damages, does Peterson allow you to actually transfer a warranty deed, especially because the 4 acres is not even part of the drainage.
Contemplates a deed being given at all. That's, no. So we are asking that the court strongly reaffirm the Hammer case that stands for the proposition that once damages for severance are paid, damages are paid in an eminent domain proceeding, whether it be severance, additional taking, or whatever other damages that the claimants make, that those damages are conclusively presumed to be total payment for all damages due to the taking at the time the damages are paid. And we think that case precludes severance damages in this case, period. And only, we're only owing the additional right-of-way taken.
Thank you.
May it please the court and counsel. In 1906, Drainage District 1 was established. It excavated a 4.8-mile ditch. 10 years later, a portion of the ditch didn't have sufficient depth to efficiently drain tributary land into the ditch. And so in 1916, Drainage District 48 was formed to establish a tile drainage system and to reconstruct Drainage District 1. In 1916, DD 48 cleaned out the lower 1.7-mile ditch and abandoned the 3.1-mile ditch upstream and converted it into a 3.1-mile tile line covered with dirt and having 35 lateral tile.
Reconcile that position with Hicks, with what we said in Hicks.
What we really have, well, I think it's important, the Court of Appeals cited the case of Barton versus Bowie, and it holds that a drainage district has an easement in land for its purpose, and a purpose can be a ditch, a tile line, or some other feature. And that case also cited the 1913 Code Supplement Section 1989-A21, which says the board may cause all or any part thereof to be converted to a closed drain, a tile line. So in 1916, Drainage District 48 converted the 3.1-mile ditch.
I mean, why aren't your clients essentially asking the district to pay for this, what it already paid for in 1906? 1906, it paid for a ditch.
But
you know, over the years, there was earth on top of, on top, and your clients got the benefit, or their predecessors got the benefit of farming that land, for which they paid property taxes in return. But now the district is insisting on its rights again, but it already paid for those rights, didn't it?
Drainage District 48 abandoned the 3.1-mile ditch, and
Officially, just because it was covered?
converted it. And the Barton versus Bowie case holds that the drainage district has an easement for its purpose. In 1916, the purpose actually changed. They converted the 3.1-mile ditch into a 3.1-mile tile line covered with dirt.
And I got to push back a little bit on your purpose theory. It seems to me the purpose all along has been drainage, and there's a couple different methods, an open ditch or underground tile. Why don't we just look at the fact that drainage district throughout this history consistently operated a system to drain lands, and therefore no abandonment?
The lower 1.7 mile ditch has remained. The 3.1 mile ditch was converted to a tile line, and the farmers were able to farm it. It was put back on the tax rolls. But the issue is really, in 1916, the purpose of Drainage District 48 was to have a 3.1 mile tile line covered with dirt, not an open ditch. It abandoned the easement. And section 468.27 was in effect, came into effect in 1985, and it says also the drainage district is deemed to have an easement in accord with the survey and report of the engineer. And the survey and report of the engineer in 1916 was for a 3.1 mile tile line covered with dirt and 35 lateral.
Abandonment necessary for you to prevail on your claim?
Interestingly enough, the district court said there was no formal abandonment, but in fact, there was an abandonment because it was converted from a ditch to a tile line. And the trial court goes on to say, the court, on page 17 of their ruling, the court finds that proof of legal abandonment is not necessary under these facts. And the court looked at the fact that for 80 years, the farmers had been farming the ground, and it was all productive land.
Question is, if the drainage district paid for a right-of-way that entitled them to a ditch of a certain width for this 4.8 miles, and then they made a decision to change it to a tile line for part of it, that made the right-of-way or the easement less onerous on the property owners, why should they then be penalized for converting the ditch back to the original right-of-way that they paid for? I mean,
I don't think they're penalized. What I see is for 10 years, from 1906 to 1916, there was indeed a severance. And the testimony showed that when they converted the ditch back to a tile line, there was still some spoils that were along the ditch. And the farmers had to, at their own expense, put the spoils back over where the tile line is. So when you talk about being paid, actually, the farmers had more expense to put the spoil piles back over the tile line.
change what the drainage ditch legally paid for unless there's some sort of legal abandonment, which I think you're saying didn't happen, right?
But the drainage district, DD 48 in 1916, made the decision, we are going to convert this ditch into a tile line. And they had to know at the time, there undoubtedly was some severance damages paid, but that covered 10 years of severance. And also now the farmers are going to be left with needing to put the spoil piles back over the tile line. So the farmers probably had more money out of their pocket. But what,
In 1906 was for forever, right? It wasn't just for 10 years worth of that.
I don't think so, because the Barton versus Bowie case says a drainage district has a easement for its purpose, and it changed its purpose. In 1916, it changed the purpose from a 3.1 mile ditch to a 3.1 mile tile line.
Can't we hold that the purpose remained the same all along to drain?
The Barton case also signs the 1913 statute that talks about cause any part thereof to be converted to a closed line. There is a difference and a distinction between a ditch and a tile line. And what has happened here is Drainage District 48, in 1916, converted the ditch to a tile line, and that means they abandon the purpose of a easement for a ditch, and they converted it also to an easement for a tile line. And that's what 46827 is saying, that a drainage district is deemed to have an easement in accord with as shown in the engineer's survey and plat. And the engineer's survey and plat, as of 1916, was for a 3.1 mile tile line covered with dirt and 35 lateral. And that's where the trial court properly said, in this situation, the court finds that proof of legal abandonment is not necessary under these facts. And again, the easement changed in 1916 from an easement for a 3.1 mile ditch to a 3.1 mile tile line covered with dirt.
Getting around the doctrine of abandonment. I mean, you say it changed, it wasn't abandoned, but it changed, and that has the same effect as abandonment, right?
Well, I think it was abandoned. It was converted. In 1916, the open ditch.
Wasn't it still draining? Wasn't it still draining?
Draining, but by a different matter.
I'm a rural girl. I've been seeing drainage ditches my whole life. And even though we can't see it from the surface, it was still functioning as a drain, right?
It was draining, but the landowners had the ability to farm the ground.
It'd be great if that could always happen. And I guess that doesn't change that, maybe because of technology and we're just better at it, but it didn't change the fact that you couldn't still accomplish drainage without an easement. I mean, there had to be some sort of capacity for the county to continue to drain under the ground, even if the farmers could use the top ground. Isn't that just kind of win-win?
Again, it's a different type of drainage. And the farmers were paid for 10 years of severance, but then the drainage district decided we are going to convert.
Analogy, but I live in a building downtown, and we have a stairway that's between our building and then the building next door, but the stairway is clearly our building. And the other side gets to use it. It's 25 stairs. I've been doing it for years. 25 stairs, and the other side gets to use it. If all of a sudden we put in an amazing new way of getting to the top of the stairs, and the easement, I have no idea, it's probably over 100 years old. The buildings are old. Do we get to go back and ask for new terms because we thought of an awesome way to get up there, a magical lift of some type? How is that any different?
But we have here an abandonment of the easement.
I'm not going to use my stairs anymore. I'm going to use my magic way of getting up there. So is that abandonment because there's another way to get there? The analogy that I gave you with stairs, I'm not going to use those stairs anymore because I have a different, better way of getting up there. Does that mean I've abandoned it?
Well, I'm not sure. I think probably it was abandoned. It's no longer being used. It's converted to some totally different method, and so.
Chairlift. Oh, well, but my point is it just doesn't seem like an abandonment if somebody improves something. Anyway.
Our position is that the easement is in accord with the purpose of the drainage district to have a tile line and not a ditch, and in accordance with the engineer's surveys and report, which is a tile line and not an open ditch. And now they're coming in and after 80 years of use, as the trial court noted, they're now having a severance, and the 1990 project was specifically that the ground still was to be able to be farmed. So obviously our position, there was an abandonment. The trial court was correct that the landowners are entitled to severance damages. Thank you.
Goodwin. Mr. Cady.
Thank you, Your Honor. Just a few brief comments. We fought this abandonment argument all along the way, and so did.
Restart the clock. That's all right. You're getting more time this way.
I don't think I can talk that long, but sure.
Hold on.
Thank you.
That.
The issue of abandonment, that's been dealt with by 3 different courts. More or less, it started with Hicks. And they didn't call it, they didn't go in and say it was abandoned, but they said that the county had lost rights due to adverse possession and prescriptive easement and all those things. And this court in Hicks shot them down on that. They said, no, the district did not lose any rights that were originally granted when the district was established.
Did the county in 1916, when it had a survey that said we're now going to have part of this be by tile instead of by a ditch, did it change the easement that it wanted or that it had?
Well, in the drainage district records show that when it was originally established as Drainage District 1 and then renumbered in 1916, that there were no recorded easements, but the Drainage District records, if anyone wanted to, could go to the auditor's office and see where, what had been granted previously, and that has been true ever since the establishment of the district.
When looked at it after 1916 and they saw the survey showing a tile instead of a ditch in that 3 mile section, what would they think would be the easement that the county would have?
They would also, if you would have gone out to the land and seen what was there after that 1916 project, you would have seen the original ditch expanded in width with dirt on the bottom that I don't believe was crossable at the time. The ability to cross that ditch occurred gradually from 1916 to in the mid-30s. So the landowners clearly would have been notified and would have known from their own familiarity with their farms as to what the district was claiming as an easement. It was open and obvious and there for all to see. Plus, in 1916, if they had any additional damage claims for additional land taken, they could have made those at the time. So I think all those things conclusively presume that the district did not. They paid for the ditch, and they paid for everything subsequent to the ditch. Now, I think the issue of abandonment is also a fact question, that the trial court made a specific finding of fact that there was no abandonment. And I think that fact question is binding on both the Court of Appeals and this court. So I don't think we go back and revisit abandonment. I think we're talking about the damages that are due and payable and not about abandonment. As was pointed out during Mr. Goodwin's art presentation, the purpose never changed. The district always used this property for drainage. And the form of the drainage mechanism may have changed over the years based upon technology and engineering, but the basic purpose always remained. And I think you just can't you can't make the district pay for something they've already paid for. What they still owe for additional takings is fair game, and we recognize that, and we owe money for the additional taking, but that's as far as I think we can go in this case.
Inconsistent to say that, that the property owners are not entitled to severance for the expanded ditch, but that the Reed property is entitled to severance for the 4 acres?
And I think those are two separate issues that the trial court dealt with separately, the Court of Appeals dealt with separately. And again, I think that as I recall the facts, the expansion due to the 2017 project landlocked Reed Meyer in a way that had not been severed before.
Not landlocked in 1906? Okay, thank you.
Thank you.
The case of Abbas versus Franklin County Board of Supervisors is hereby submitted. We'll now move to the interest of NF, and we'll have a little pause for the parties and the attorneys to get situated.